Welcome once again to The Law Matters. Of course it does. Hi, I'm Debra Morais, your host and moderator. This long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law matters because the law matters. A better understanding of the law puts you in a better position to decide how to protect yourself, your family, and in some cases, your business. As we present various topics, you may decide that you can handle some issues yourself. Our goal, of course, is to help you be the best prepared that you can. And if you decide to choose outside counsel, you'll be able to help them too. As always, our goal is to help you to achieve the best possible results while saving time and money. And as always, we want to, again, welcome Attorney David Bazar from the Bazar & Associates law firm in East Providence, who continues to weigh in on the various topics that we discuss. Today, torts, personal injury, negligence. As Benjamin Franklin once said, a little neglect may breed great mischief. Negligence, even its nuances, can also breed many lawsuits. Many people don't fully grasp what the concept is. Imagine how much more confusing it can be to know that there are variations of them, different types of negligence, and they're identified by varying degrees and the circumstances that are situational. Lost yet? Interesting. So we are going to talk about what's considered reasonable. Is that a debatable issue? What is strict liability? Who's liable and when and why? So we'll talk about a few examples and give you some of the legal factors that impact on various situations and that lead to personal injury and torts. Apparently, the rule of negligence is the most commonly used rule when it comes to tort liability. We've talked about personal injury and torts in the past, so can you give us a quick overview of it, and then let's get to how negligence factors into these cases.
Okay. So if you want to talk about it in legal terms,
yes.
If we're in first year of law school tort class, what is the definition of negligence? So typically, you start with there's a duty, and the person who is being charged with breaching that duty, the defendant or tortfeasor, has the duty owed to the person who is the injured party, and they breach the duty, and then is the breach of their duty the proximate cause of the injury or damages, and then what are the damages? So let's take that definitional aspect of negligence and put it to practice. So, car accident. First thing is, what is negligence in a motor vehicle situation? So if you're stopped at a red light and the driver behind you hits you, what did he do wrong? Well, he had a duty to stop his car before it hit your car. And he breached that duty by hitting your car. So there's clearly the first two elements of negligence. So what happens next? As a result of hitting your car, what happened to you? What were your damages? And so that is what the whole package in an auto accident would be in terms of negligence. The duty not to hit the car, breaching the duty, hitting the car, proximate cause causing you your injuries. And now that's where most of the lawsuits in an auto accident kind of rear end situation, the issue is what are the damages and what was caused by the accident and what wasn't caused by the accident.
Yeah, what was caused by the accident, what wasn't. So there's something that's called, I guess, strict liability. There are plenty of occasions when someone might say that driver who rear-ended, well, things were happening. There were circumstances. Are those at all viable, or is it just and only you hit that car that makes you 100% culpable and negligent?
Generally speaking, when you rear end somebody, you're probably going to be 100% liable. Mm-hmm. And then you can try to think of defenses as to why that happened that were beyond my control, so to speak. Did I act as the reasonable person would have acted? And so that's a difficult situation because you make an argument on one side, as the lawyer on the other side, I'll make a counter argument. Okay, for example, it was snowy and it was slippery, and I didn't create the slippery road, but when I tried to stop, I couldn't stop because it was slippery, so I hit the car in front of me. It was an act of God. Nope. The argument on the other side is, well, it was snowing and it was slippery, so you should have been going even slower to control your car as a reasonable person might do.
So someone interjects, I was going slower. I started pumping those brakes X feet before I should have. I was almost stopping. I was rolling. I wasn't even driving. Why is that? Why am I being am I negligent? Or was that a breach of my duty? My duty was to apply those brakes and slow down. I did.
Yes, and if the circumstances are such that you were going so slow that even though you hit the car, it was at a very, very low speed, then what damage did you cause to the other person? So you have to look at all the factors in situation, but generally speaking, if you hit another car, you're probably going to be considered negligence, as opposed to those other type of negligent cases where we deal with slip and falls, for example. And you slip and fall in the supermarket, and there was something on the floor. But what happened was the thing on the floor was knocked over by another customer a minute or not even a minute before you walked through it, and they had no opportunity to fix it. So did they breach a duty to you in that circumstances? Again, it's subject to debate, and one lawyer can present it one way and another lawyer the other. But if they didn't have a reasonable opportunity to cure the defect that they didn't cause, then that might be a hard case to prove that they breached a duty.
Let's go back to that automobile accident for one more moment. Suppose a person said, I pumped the brakes failed. What was the manufacturer's fault? You could prove, I suppose, that in fact there is something wrong with those brakes. You could reasonably say, I, as a driver, didn't cause those brakes to fail. That what the line broke. I don't know enough about cars to explain all the mechanics of it, but it was the car's fault, not mine. Reasonable, not reasonable, acceptable?
Possible.
Okay.
Again, I'll come up with other arguments that you're still negligent. For example, did you do all the proper maintenance on the car?
When did you check your car?
When was the car checked last? Were you having problems with the brakes before you went out that day? Had you had problems with it on other days? So again, things we'll definitely look into, but if it was a serious enough situation with catastrophic injury, you may look at a products liability case. You may look at, did the mechanic who worked for General Motors, just throwing that out there, deep pocket, we like the deep pockets in tort cases, do something negligently in repairing or not properly repairing or maintaining the vehicle for you, and they have some culpability, then perhaps, because isn't it foreseeable? And that's one of the big things that you need to look at in causation and damages in tort cases. Is it foreseeable that if I, the mechanic, didn't properly fix the brakes on somebody's car and they drive and get into an accident and really injure somebody, that is a possibility that could happen as a result of my breach of my duty to repair correctly?
So when we talk about what's reasonable, the simple scenario is it's snowing, it's inclement weather, you should slow down, pump your brakes, make sure that they work. If there is a case, is it always in front of a jury, and is the onus always on them that you're to assume they are all reasonable? Some may be, some may not be. How do you
So like any other case, first it starts off with a claim. So if you were injured as a result of someone's negligence, you file a claim with them. If they're insured, usually it's turned over to their insurance company, and you try to resolve those claims. And if they can be resolved, that's the end of the day. If they can't be resolved, then there's other forms of dispute resolution, as we've talked about before, mediation, arbitration, those types of things that may or may not take either pre-suit or after you filed suit. So if you file suit in a tort action, a negligence claim of some type, and you're in Rhode Island, for example, you have a right to a jury trial if it's in Superior Court. So you claim when you file for a jury. And if you resolve it beforehand, obviously it's done and doesn't go forward. But if all the attempts at resolving the case fail and it's going to be tried, it can be tried in front of a jury.
So the onus is on the defendant to say, I did everything I could. I wasn't negligent. The onus is on you to prove, well, no, you didn't do everything that you could.
So the plaintiff bears the burden of proof in a civil case.
The plaintiff
does. The plaintiff does. So if I claim you did something wrong, it's my obligation to prove to the jury you did by a preponderance of the evidence.
Preponderance.
Not a criminal case beyond reasonable doubt, a preponderance of the evidence. So what is a preponderance of the evidence? It's more likely than not that what I'm saying is correct, or a scale 51% to 49% to tip the scale. I just bear the burden of proving to the jury that what I'm saying is more likely to be correct than what you're saying.
Okay. Of the things that I had researched, it was very interesting to hear that question answered about, is a reasonable person test objective or subjective? Some things seem quite black and white, as we discussed. You applied your brakes, you didn't. They worked, they didn't. But the answer was it's objective. A reasonable person test or a reasonable judgment is considered objective and not subjective. Comment on that, David? I mean, I'm not asking you actually just legally, but comment.
I agree that what you're talking about is in trying to prove whether someone breached their duty is did they act reasonably? And so the reasonable person test is actually in the objective, looking at how any reasonable person would act. Did you act in accordance with that norm? Here's the thing. You also do look at who the person is and apply that standard based on who they are. So in a medical malpractice case, when you're looking to see if a doctor did something wrong, it would be a doctor with the same type of training and knowledge that the doctor in this particular case had in determining whether they breached the standard of care. In an automobile accident, it's a reasonable driver, that's what you look at. If there's a case against a child, for example, where there's an allegation that the child did something negligent, you look at the age of the child. That's a factor. Did they act as a reasonable 12-year-old would have acted in the circumstances? And so you do take a look at the person and then ask, are other people with the same situation, would they have acted the same way? In other words, did they act reasonably?
So we know that there are television shows that actually have as the major premise, there's value in assessing and selecting the jury. You're trying to determine whether or not that person, when it comes down to it, will be likely to side with you or not. And you are, as during jury selection, trying to decide whether or not that is a suitable, acceptable jurist. I'm thinking that that certainly substantiates it. It seems that there may be some people who seem reasonable and yet they have a bias. A bias can still seem to play into the case of it still being objective. Yes?
So we sort of jumped from the legal standard to how is a jury going to react to what that standard is in applying the law to the facts.
Yes, reality.
And so in reality, what you're looking at is, depending on the type of case, jury selection can be very different for different types of cases. So if you're looking at an automobile accident where someone has severe injuries and you're trying to pick a jury, you do want to know a lot about the people who you're trying to pick and what their biases might be. For example, would they have a bias against awarding money to somebody who was injured? And how do you know? There's a lot of different things you'd have to look at. What's your job? Where do you work? Oh, you work for an insurance company. Maybe not somebody you want on your jury if you're the plaintiff, that type of thing.
Good example. You mentioned a 12-year-old and what's considered to be a reasonable 12-year-old. I would think that might be subjective too, but addressing the legal fact, is that one of the issues that would come into play when someone is accused of a crime or accused of being negligent in a situation, but you'd like to have them tried as a child, not as an adult, because there are different standards? Is that part of what plays into that, David?
Yeah, we're cross-pollinating a lot of different things.
Yes, we are, but
here.
I just couldn't resist the temptation,
right.
David.
So, very big difference between civil cases and criminal cases. And a juvenile or a child, there's a whole different issues and factors in how they're going to be tried criminally if they did something that violates the law in a criminal nature. Civilly, usually we're not talking about suing a child who's 12 years old. That's
Surely,
not something that's
surely.
going to happen.
The parents.
But perhaps, and there's a lot of difficulty even usually in doing that unless the parent was negligent in doing something, in monitoring or watching the child or doing something and let the child do something that they shouldn't have done. A whole lot of different things that go in there. I was just using the 12-year-old,
Sure.
not as an example of a 12-year-old, but
Certainly.
of a factor that you might look at in determining what the reasonable person's standard is.
So I imagine if the 12-year-old is driving and there's not a parent around, the fact that the parent is letting or not stopping that child from getting behind the wheel seems like the parent might have some culpability there.
It's the parent's negligence you're looking at. You're really not looking to determine whether the 12-year-old drove properly as a
Yes.
reasonable 12-year-old.
So in addressing what negligence is, there is slight negligence, ordinarily negligent. There is gross negligence. Can you explain the differences between some of them and perhaps maybe give us an example? I have a few.
Yeah, so in a civil case for negligence, usually you're just talking about negligence, not gross negligence, although that can factor in, but it's not really supposed to factor in a general sense of what the damages are, because the damages are the damages that were actually incurred.
Oh, good to
Whether
know.
somebody was grossly negligent or negligent, it really, that part of it shouldn't factor into what your damages are.
So how does that apply when gross negligence, maybe it's something that's almost intentional? Someone wouldn't get more damages if you
That's-
happen to see that?
Gross negligence is not an intentional act. It's starting to get towards a reckless act.
Reckless. Okay, so what's the difference between gross negligence and reckless? I was going to go there, but you're already there.
Okay. So an example that could be given of somebody that was negligent would be they're swinging a tennis racket outside and they're not looking at their surroundings and they hit somebody who's walking by. Gross negligence might be they're swinging the tennis racket inside and there are some people in the room, but they didn't really pay attention to the people that were closer to them and in the room. Recklessness might be they know there's people all around them, and despite the fact that they see the people and they know where they are, they keep swinging the racket and hit somebody. Not intentionally, but with such disregard for the safety of
abandon.
others, they were reckless.
How does that impact on a case when something like that is taking place?
Well, it depends on what kind of case it is and what you're suing the person for.
Someone got hit in the head when someone swung that racket,
Yeah.
and there's a group of people.
Right. So again, the reckless standard versus the negligent standard in a civil case doesn't have a big difference because it's the damages that are incurred that you're going to seek as a result of the act. But if you want to cross-pollinate back into criminal stuff, that's where that really is going to factor in.
Good point. In one case that was described as being slightly negligent, a person who was a mechanic repaired the brakes on a customer's rare vintage Ferrari. As the story goes, the brakes ended up failing, the person had an accident, caused a crash, caused some injury. Normally, the fact that the Ferrari had a rare, complex braking system could mean that Sam's duty of care was not extending to that situation so that he'd know every detail of what needed to happen. However, Sam says that already claims that he's an expert in rare or vintage Ferraris and other kinds of cars. So now does the plaintiff get to say, Sam, you are definitely on the hook because you are stating that you're positioning yourself as being an expert.
Well, so the violation of the duty of care of the reasonable person, if Sam is an expert or is claiming to be an expert, then he's held to the standard of care of that Ferrari expert that breached his duty because he didn't do it correctly. As opposed to you went into your local garage, he's trying to help you, but he's not a Ferrari expert, and he's telling you, I'm not a Ferrari expert, and what's the standard of care that the garage guy who's, running out to pump the gas and fill the tires and is saying, I'll try to help you here, but this isn't my area of expertise. You need to go to a Ferrari dealership to get this done correctly. It might be a different standard that's applied because of their knowledge, which is what I was getting at with the 12-year-old.
Are there occasions that you have to deal with someone's being a party to or only partly responsible for it, that you yourself were causing the issue? Let's talk about, for example, summer camps. This is the time of the year we might address it anyway. What do people need to know when it comes to sending their child to camp? You may have a team of people who are taking care of or watching over your child, and something happens. Maybe the child was not quite doing what he or she should have done. Maybe there's a problem with the camp counselor or a staff member or several. How do you sort those kinds of things out when there's a case?
So it's pretty much the same standard that you would apply to any negligence case. Did the camp have a duty to supervise your child correctly, and did they breach that duty? And as a result of the breach of their duty to supervise your child, was your child injured as a proximate cause of that breach? So if they hire counselors who aren't competent to do the job that they're supposed to be doing, then that could be a violation of their duty to you. For example, they have a lake or a pool, and they hire people who are supposed to be watching your children that don't know how to swim and can't, save a child from being injured in the water. That, if you can prove that that's the case, then there's a violation of their duty to properly safeguard and supervise your children.
So you'd have to make sure that your staff could swim, could train, could do life-saving, but your child went out beyond the range of where he was supposed to. So suppose your child did something that was not within the realm of what he should do or where he should be. Does that change the nature or the complexion of the fact that there's an injury and there's likely to be a suit?
There are times where an injury can occur where it's not somebody else's fault. So let's say the campers are out walking in a trail that is not owned by the camp, and it's in nature, and they're all doing the counselors are supervising and keeping them in line. One of the children trips over a root that grew up in the path that they were walking on and broke their leg. You might try to find some negligence on part of the camp, but it might have just been an accident that happened that isn't the result of somebody else's fault.
No negligence. The camp counselors are together, they're fooling around, and I guess that it could happen that they took their eye off whatever was going on for a moment and someone is injured. Difficult to prove? Is it one person? Do you have to go after all of them and find out who did what and who was looking which way the very moment that child had something happen? How does that play out?
So back to reality. Mm-hmm. What you would do is you would sue the camp because these counselors who, whichever one or all were negligent, are agents of the camp, employees. So the camp owner, the camp itself, is responsible for the negligence of its agents or employees. And so you sue the camp, not the counselors.
Okay. For the parents who are thinking about sending their kids to camp, all of them have a very lengthy waiver, and I'm sure some of them read it, some of them don't, but the waiver often has some sort of language that says, we're not completely, I don't know, what does it say, David? That we're not completely responsible for every single thing that could happen, but you can bet that if something happens to a person's child, they are going to pursue it. Let's just say that. So how do you what would you say to the parents? What do you say to the camp in how to best address this, and what do people need to know?
Yeah, so the waivers can be effective for some things, but you can't waive things that you don't know and things that haven't happened yet, potentially. So if the camp was negligent, in some form or fashion and your child's injured, you're probably still going to be able to go forward with the suit. It's always a good idea from the perspective of the lawyer for the camp to say you should have these waivers and try to make them as airtight as you can, but they're never 100% airtight against everything. So that's that.
Does it make sense these days, as we always say, document, document, document? Many are having videos of every soccer field in which the kid plays, maybe now even at the lakeside when they're starting to swim. Certainly that would give whomever needs proof some proof.
Yeah, yeah, and we have cameras everywhere these days
Don't
too,
we?
so there's oftentimes much better chance to actually see what happened and get it because of the fact that there are cameras everywhere.
So let's give one more example, not at a summer camp, but rather at your home. You have a pool, you're having a pool party, you have 30 people, you have the young children, you have grandmas and grandpas. You're at the grill, your wife is making food or setting it out, and the children are playing. Let's say they all have family members around, but some parents are having drinks. Who's helping you grill? Not everyone is watching. Who knows what can happen? Who ultimately, if you are the host, are you ultimately only and exclusively responsible if something happens to that child when, in fact, should the parents have some culpability? How do you address that?
It's difficult. We would always, if we have a pool, we would tell any parent who brings a child, you're responsible for watching your child.
Do they have to sign a waiver?
We don't make them sign a waiver, but there's no lifeguard. We tell them there's no lifeguard. It's a private home. You wouldn't expect there to be a lifeguard.
Certainly.
No diving, and my wife actually puts up signs that say no diving, and we tell everyone or anyone who's coming over that these are our rules and this is what you want to do. I don't know if that is enough to shelter us from liability if some tragedy happened, and I would hope that that never happens.
Of course.
But that's what we try to do.
You're certainly not being negligent if you've warned everyone and you say, I'm grilling, my wife's serving, please watch your kids.
Right, right. And so you try to do everything you can, but that's, if some tragedy happened, I would always expect that at least an attempt would be made to make a claim against the homeowner.
Sure, but in this case, you're saying you do all that you can, so yours is not a breach of duty to the extent
That's what you would hope, and it's up to the insurance companies and the courts and the juries eventually to decide what more could you have done. As you said, I pumped the brakes.
Well, we hope that these examples have been helpful to you. We hope that you've gained some insights into what negligence and personal injury and torts are and what you can do to perhaps avoid them. Stay safe. Thank you for tuning in to The Law Matters. As we say, it matters to you.